According to Christian historian, author, and political activist David Barton in his monumental work Original Intent, the Courts, the Constitution, and Religion, the question of what the founders intended as the proper relationship between religious expressions and public life, whether in education, law, government, or throughout society in general, is clearly documented in their numerous writings on the subject. Those records establish their intent and thus clarify their two references to religion in the Constitution. The first reference is in Article 6, Section 3. No religious test shall ever be required as a qualification to any office or public trust under the United States. The second is the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. The religion focal point of the First Amendment has been the most debated, and I would argue most misinterpreted section of the Constitution. Beginning in 1947 with the Supreme Court's decision in Everson versus Board of Education, broad interpretations and modern majority opinions have been imposed on the original intent and context of the First Amendment. As a result, religion, most notably Christianity, has been legislatively forced out of public schools, business, government, really any public sphere. Public school prayer and Bible reading were deemed unconstitutional by the Supreme Court in the case Engel versus Vitalo in 1962 and Murray versus Curlett in 1963. In 1980, the Supreme Court ruled that displaying the Ten Commandments in public schools seemed to serve quote, no secular legislative purpose, thus making it unconstitutional. The now almost universally accepted and quoted phrase to defend the expulsion of religion, specifically Christianity, from the public sphere, separation of church and state, can be traced to Leonard J. Kirpelman, a Baltimore lawyer, who successfully argued a landmark Supreme Court case in 1963 on behalf of avowed atheist Madeleine Murray O'Hair, banning state-sanctioned religious prayers from public schools. Kirpelman asserted that the Constitution had erected, quote, a wall of separation between church and state, end quote. The only dissenting judge in the Murray versus Curlett case, Justice Potter Stewart, interrupted, asking where this wording appeared. An embarrassing silence followed, broken by Kirpelman admitting that the text was not explicit on the point, but that it had been interpreted to mean so. However, relying on an interpretation concocted by the court nearly 200 years after the Constitution was written, rather than on the actual wording, context, and original intent of the Founding Fathers, is not only unscholarly, bad history, but also dangerous. Noah Webster, a founding father and author of America's first standardized spelling dictionary, warned of the misinterpretations and serious errors that would result from ignoring original meanings. He stated that, quote, whenever words are understood in a sense different from that which they had when introduced, mistakes may be very injurious, end quote. If one takes the time to read the intention and rationalization of the authors of the Constitution, no such modern twisted interpretation of a wall of separation between church and state can be truthfully construed. James Madison, architect of the Bill of Rights, stated that, quote, the civil rights of none shall not be abridged on account of religious belief or worship, nor shall any national religion be established, end quote. The Annals of Congress from June 8, 1789 to September 25, 1789 contain the complete official discussions and debates of those who drafted and supported the First Amendment. From reading these actual primary sources, the founders' purpose was simply to prevent the establishment of one national or state religion or denomination, not to separate itself from or restrain public religious expressions. Congress or the federal government was to make no law. or to establish or prohibit religion, not states, communities, schools, or individuals. However, under the modern misconstrued interpretation of the court, Congress now pertains to students, teachers, business owners, public officials, and any public establishment. Make no law now is interpreted as the prohibition of expressing the Christian faith in any form, and an establishment of religion now means any public or private display of Christian principles or references in an official public forum. This bizarre modern interpretation, which renders Congress, which is an elected body of the national government, as private citizens and make no law, that is a permanent punitive legislative action, as equal to any expression of one's personal faith in any public forum, has resulted in major consequences for our nation. First, it has resulted in a dramatic expansion of the federal government and provided the federal legislative branch with the power to violate the First Amendment's prohibition to not interfere with states' or individuals' religion. For over 16 years now, the federal government has been interfering and imposing itself as the sole interpreter of the Constitution and violating states' and individuals' rights to freely exercise their religion. Second, this interpretation hasn't really succeeded in separating the church and state, but the state from God. That has been the court's ultimate purpose since these modern rulings, to dispel any public acknowledgement of Christian moral authority and mankind's accountability to God, and to replace it with the religion of atheism. Justice Potter Stewart, the only dissenting judge in the 1963 court ruling, understood where the court was leading our nation when he confirmed that it led not to true neutrality with respect to religion, but to the establishment of a religion of secularism. Supreme Court Justice William Rehnquist years later made a similar grim observation. He said, "But the greatest injury to the wall notion is its mischievous diversion of judges from the actual intentions of the drafters of the Bill of Rights. The wall of separation between church and state is a metaphor based on bad history, a metaphor which has proved useless as a guide to judging. It should be frankly and explicitly abandoned."